Brian K. Kirkham presiding, calling case 2022-2134 DM Aaron Gentry versus Peter Gentry. Today is Monday, December 23rd, 2024 at 9:36 a.m.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion to require plaintiff to comply with the judgment of divorce. Obviously, I've read the pleadings in this matter, Ms. Thomas. You don't have to reiterate those. Do you have anything in response to Ms. McNiff's answer?
Well, there's a lot of things to respond to because there was a lot of inaccuracies in there.
Well, let's respond to the salient points. There was a lot of ancillary and I believe superfluous stuff included, and I don't need you to respond to that.
Okay. All right. So the issue is, of course, whether or not and when Ms. Tinsman has to respond or has to remove his name from the obligation. The concern is that now we've learned that her intent is to not do so for another 18 months. The problem, or to even list the house for sale for another 18 months, which would even be beyond that. But the problem of it is that it's affecting Mr. Gentry's credit. It's affecting his ability to do other things at his house and ownership of his house. And so it was supposed to be to hold him harmless. And in the response, there's several things that aren't true, including, who had the affair. I mean, there's all kinds of things. But again, as you indicated, they're ancillary things. The bottom line of it is this case was one where Ms. Tinsman's attorney drew up the document. Mr. Gentry was not represented. It was after he had met with both of the parties, and they both were of the understanding at that point that she was going to refinance and get this taken care of right away. It's now more than 2 years later, and nothing's been done. And it seems that Ms. Tinsman is of the belief that she can do this if and when she wants to, and it is affecting his credit. It is affecting, there's all kinds of excuses, but every excuse is one that frankly is under Ms. Tinsman's control. We just are asking for a date by when it needs to be done, because one wasn't put in the initial judgment of divorce that was prepared by Ms. Tinsman's attorney. And then again, the amount of things in the response were a little flabbergasting for us, quite frankly, but there are 5 missed payments according to the document from the credit union. And so we're just simply asking that there be a timeline put on this matter.
Okay, thank you. Ms. McNiff, you talk about all sorts of things in the response. What's the date that she'll have this refinanced by?
Your Honor, as we responded in detail, the problem she's going to have is that the financing companies want her to have 2 years of either W-2 or 1099 wages. And she simply doesn't have that. And so she won't be able to refinance until then. She certainly wants to sell the house sooner than 18 months. But we need a resolution of the parenting time issue. I'm going to have to file a motion, I think, to resolve that and to get that to a hearing.
Okay,
but
that's not before we made a date.
No, I'm just, and I understand that. She has an intent to sell.
Give me a date.
I don't have a date, Your Honor. I don't. But the big thing here, Judge, is a judgment of divorce for the property provisions is really a contract. And it's not for the court to reform the party's contract. It should have been on Mr. Gentry to ask for a date when he wanted his name off of that property. And without that being in the judgment, there is no date. I think that Mrs. Tinsman will do it, but the judgment speaks for itself. Okay.
Well, in this matter, it's been approximately the judgment was back in on February 13th, 2023. So we're going on close to a year. Obviously, that's sufficient time to get the matter resolved, and the court's not going to wait indefinitely for the plaintiff to qualify or whatever. And because we can't be given a date, the court is going to order that the house be sold, listed for sale forthwith, and be sold. If something happens in the meantime, she's able to refinance, the court would would consider that, but at this point, if there's no date, that she's gonna have to list it for sale and have it sold forthwith and provide Ms. Thomas with the listing agreement. I will require that that be done within 14 days of today's date.
Judge, could she have a little bit more time just
Nope.
due to the holidays? It's going to be
She's had
difficult.
sufficient time. She can do it within 14 days. Thank you.
Thank you, Judge.
You
Thank
got it.
you.
You can submit that, Ms. Thomas, under a 7-day.
Will do. Thank you.
Thank you. Have a good day and a good holiday.
Thank you.
Thanks, you too.
9:19 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Thomas on behalf of defendant.
Guys, today we enter a legal showdown. A name on a mortgage turns into a full-blown war. She gives excuses but no real date. Every delay tightens the pressure inside the courtroom.
Matter is before the court on the plaintiff's motion to modify parenting time. She says, due to the intent of the plaintiff to move to Virginia. Go ahead, Ms. McNiff.
Thank you, Your Honor. I know the court is familiar with this case and has read the pleading, so I'd like to just respond to the answer if that's acceptable to the court.
That's fine. I don't need a reiteration of everything in the pleadings.
Thank you, Your Honor. First of all, we're offended by the fact that in the answer, they indicate that my client became pregnant with her boyfriend. In fact, my client was engaged to her now husband when they had an unplanned pregnancy. We feel like that's simply a dig that was unnecessary in the answer. But the big issue here is that Attorney Thomas indicates in her answer that the referee could have set up a parenting time plan after the change of domicile hearing, but didn't based on the children's best interest. The fact is that the time of the hearing, there was no request by either party to have a change in parenting time if there was no change in domicile. The request was to change the domicile and change the parenting time in conjunction with that change of domicile. The court denied the change of domicile and simply did not have a change of parenting time because that request wasn't on the table. Mrs. Tinsman has now made the decision to accept that finding and intends to move to be with her husband and their infant child in Virginia at the time that the Battle Creek house sells. While the court certainly has the authority to prevent the children from moving to Virginia or changing their schools, Mrs. Tinsman is free to move to be with her husband as she sees fit. Mrs. Thomas believes that the parties can continue with the current week on, week off parenting time schedule even after my client moves to Virginia, but that's simply untenable. It's ludicrous to think that anybody could do that. Mrs. Tinsman has a 7-month-old child who will eventually attend school. The party's youngest child is 6. To think that Mrs. Tinsman can travel every other week from Virginia to Michigan for the next 12 years is absolute insanity. She can't afford to buy a residence in Michigan now that her house has been ordered to be sold, and she can't afford the high cost of rentals on a bi-weekly basis. There needs to be an alternative parenting time plan put into place that accounts for this move. This is going to be a big issue when this house sells. Ms. Thomas argues that the house selling and Mrs. Tinsman moving is not an ordinary life change, but she's simply wrong, and it's absurd it's an absurd argument that this court should absolutely not entertain. Selling the family home and moving out of state is absolutely an ordinary life change as contemplated in Shade v. Wright. We could wait until the house sells and then renew our motion, but we think that it makes sense to prepare for this eventuality in the event that the house sells very quickly. The court ordered that the house sold. There is a listing agreement. The listing for the house is going to go live this coming weekend with photographs, and we would anticipate that it will sell fairly quickly. Ms. Thomas also indicates that we're asking for a 50-50 parenting time split, which she knows is absolutely untrue because she sent us a proposed parenting time plan and we sent a counteroffer, and neither contemplated a 50-50 split. It's simply ridiculous to think that the parties could live in Virginia and Michigan and have a 50-50 parenting time split. We know that can't happen. She further argues against herself, saying on the one hand that an equal time division isn't necessary for joint physical custody, and on the other hand insisting that Mrs. Tinsman maintain the equal division of parenting time by commuting. We understand that there can't be a 50-50 split. We've never been proposing that, even when we were asking for a change in domicile. I'm frankly incredulous that Ms. Thomas alleges that Mrs. Tinsman wants to take away all of the school holidays from Mr. Gentry when she knows that that is absolutely false. Mr. Gentry's offer was in accord with our counteroffer, and the parties were in agreement on all of the major school holidays, including Memorial Day, Labor Day, Martin Luther King Day weekend, the midwinter break, the spring vacation, the Christmas vacation, and the Thanksgiving vacation. Where they got hung up on was how much time each of them would have during the summer vacation, the Independence Day holiday, and who would pay for transportation. Those were the big hangups. So to say that we're asking for all of the school holidays and making that seem like my client is being selfish is absolutely fallacious, when that was part of a proposal that they sent to us. The big issue here, Your Honor, really is who's going to pay for or provide the transportation for the parenting time when my client moves to Virginia. This court's policy in the past to not necessarily make that an equal division. The moving party should bear perhaps more of it, but it's also never been this court's policy that one party has to bear the entire burden of transporting the kids for parenting time. We're not asking that there be even a 50-50 split of the transportation burden, but we are asking that Mr. Gentry be required to do some of the transportation, perhaps for the big holidays like Christmas and summer and spring break, Thanksgiving, things like that. Further, Ms. Thomas complains that we haven't complied with the order regarding the sale of the house, which is again absolutely false. The order that Ms. Thomas drafted specifically provides that we were to provide a listing agreement 14 days from December 23rd of last year. We provided the listing agreement to her on January 6th of this year, which was within 14 days, in spite of the Christmas holiday and in spite of the New Year holiday. Mrs. Tinsman was scheduled to meet with a realtor prior to January 4th, but the realtor contracted pneumonia and had to move the meeting to January 4th. The realtor then asked Mrs. Tinsman to ready the house for photographs. There's 4 small children living in this house, and my client had to declutter, clean, make repairs, wash crayon marks off walls, and do things like that in order to get this house ready for sale. She's been diligently working on all of those tasks since her meeting with the realtor on January 4th. And the house is now ready for professional photographs, which will occur on January 16th this week. And the listing will go live this weekend. The realtor felt that it's better to go live on a weekend in order to generate more interest, and also to have the house decluttered, looking good for the photographs so that people will have more interest in the house. Your Honor, this shouldn't be a difficult case. These cases come up all of the time. People are able to work through them. However, these parties can't, and we need the assistance of the court to try to figure out a proper parenting time schedule that will maintain joint physical custody, although we're not asking for 50-50 time, and accommodate the fact that my client wants to move to Virginia to be with her husband and their small child. The way we see it, the big differences are the summer vacation and how many weeks each party will get during the summer vacation, the 4th of July holiday. My client is looking for 1 weekend per month during the school year to be exercised in Michigan. And she would do all the transportation for that. And we're looking for some kind of division of the transportation.
Okay, thank you. Ms. Thomas?
Your Honor, a couple of things. First of all, that was not, I mean, the specificities of the parenting time was certainly not before the court, but the bottom line of it is, though, that in fact, the motion that Ms. Gentry Tinsman filed with the court initially was a change of domicile and a change of parenting time. Clearly, that motion seems to have purported that if in fact there was a move, parenting time would have to change, and that's fine. But throughout the course of that particular hearing, and which was like 13 months, Mr. Snyder considered a variety of things, and specifically, he noted in his finding that Ms. Gentry was going to have to make some specific decisions about did she choose to live with her children in Michigan or be in Michigan with her children? Or did she choose to be with her husband and a new child? And that decision would be very, very difficult for her. And it's in the finding. So clearly the court heard very significantly, in fact, about the new child, and again, there was no intent about boyfriend, fiance, not husband at any rate. Her husband, her child, the fact that she intended to move. So the court knew all of those things, and still, even though parenting time was before the court, did not fashion any kind of order that if in fact, and after specifically stating that she would have to make these difficult decisions, did not in any way indicate, well, if she chooses to move, then it would be this parenting time. And the court had authority to do that and could have done that, but the court didn't do it. And we find it, I find it very interesting this morning that specifics of what the specific issues are between the parties was brought to light when Ms. McNiff last week was upset because I said anything that there was a motion or a offer at all. The bottom line of it is that for the last year and a half, Ms. Tinsman has gone back and forth. If she chooses to, I mean, yes, the court ordered the house to be sold. It is not listed at this point in time. Irrespective of what Ms. McNiff has said, at this moment, it's not listed. And it doesn't even have to be sold. This court specifically gave the option that if in fact she got it out of Mr. Gentry's name, that it didn't have to be sold. So that is another option. She's been doing it for a year and a half. I understand that that's a lot, but I also believe that Ms. McNiff was not quite 100% honest, and not that she's being dishonest, but she left out a few things. Number one, that the initial offer was the same as what they had put in their motion for change of domicile reversed. In other words, she was willing to go the extra mile to have Mr. Gentry agree that in fact her motion would be accepted, and ultimately expected us to do the same thing. Well, he didn't want the children to necessarily move. He doesn't necessarily want the children's mother to live that far away from them. Bottom line of it is there was an offer. We countered. Our counter offer from that, they asked for more time than they asked for in the very beginning. So that, to us, that wasn't even a realistic negotiation. At this point, the court has looked at the facts of the case, knowing that there's a new husband, knowing that there's a new child, knowing that the defendant intended to move. There's no change in those circumstances. She intended it before, she intends it now. And so I don't believe there is a change. Again, selling the marital home does not mean that she necessarily has to move. The house is in her husband's name as well. They can either pay it off or refinance or somehow get Mr. Gentry's name off the mortgage. That would comply with the court's order. And again, the status quo for the last year and a half has been going back and forth. Although Ms. McNiff has indicated that they're not asking for 50-50, Ms. Tinsman continues to refer to a plan wherein she could move and maintain joint physical custody of the parties' children. And as Ms. McNiff indicated this morning, it is unrealistic to assume, because plaintiff's unilateral choices and her wants and desires, that she would solely determine the children's time with their dad either. As pointed out in our answer, again, it doesn't have to mean 50-50. And depending upon her choices, she can continue with equal parenting time if she wants to, if she chooses to stay in Michigan. But she wants to move and she wants to take the kids away from their dad and their friends and it's not, when we're talking about school holidays, we're not talking about it. The intent was not to talk about holidays as in Memorial Day, but holidays as in the non-school time. Clearly, it would not be equitable or in the children's best interest to never be able to have vacation time with their dad, because their entire summer would be with their mom. And that's a big part of what Ms. McNiff did leave out in what she indicated to the court this morning. the court has already said, and ruled, when Ms. Tinsman asked last summer to take summer parenting time in 2-week increments, that no, it's not in the kid's best interest. And so even though it would have been more convenient for her. So bottom line of it is, Mr. Gentry wants the kids to have a meaningful relationship with their mom, and he's willing to work with her. He offered a parenting plan, which quite frankly was a little more generous than what I thought that he would offer, or that I thought, quite frankly. But it would allow regular continued parenting time with the children if mom chooses to move. That was declined, and more parenting time than what had initially been asked for was asked for. The plaintiff suggested resolution wherein the kids would no longer enjoy extended summertime with their dad, where plaintiff's parenting time would not be supportive of the kids' events and activities. That's not focusing on the kids, or it's not putting their best interests first, and therefore it's not acceptable to Mr. Gentry. And quite frankly, it's also not in compliance with Michigan court case law. Your Honor, the court has heard about plaintiff's new husband, the new child, her desire to move, her intent to move. She's brought up nothing in this particular motion that's not already been before the court, and frankly, to ad nauseum. And frankly, she's not met her burden of proof for a change of parenting time. Frankly, Mr. Gentry can't continue to pay for ongoing attorney fees merely because the plaintiff doesn't like the prior orders of this court. He's praying his request for attorney fees will be granted so that the ongoing motions will stop. Again, whether this court orders an evidentiary hearing or not, Mr. Gentry is willing to work with Ms. Gentry with regard to, or Ms. Tinsman with regard to the parenting time, but to have this ongoing, constantly, forever in front of the court and expense, he can't afford to continue doing it when it's every time it's been because Ms. Tinsman doesn't like the last order of the court. So we're asking that the motion be denied, and that first of all, it may not be right because she's not moving right now. But again, there's options. It's not, the only option is not that she would live there and the kids would live here and she couldn't have alternate week parenting time. She can if she wants to. The house doesn't have to be sold. The court didn't order that. The court said if she wanted to, that the court would consider refinance or paying it off or whatever it would have to be. I don't believe that this is a motion that is well advised. I believe this court has already heard this, and Mr. Snyder, it took him a long time to do his finding. And I know that both Ms. McNiff's office and my office are both saying, when are we going to get the results? Because it did take him a long time because it put a lot of careful consideration into this. And to now go back and do a redo doesn't seem necessary. First of all, I don't believe it's properly before the court showing a change in circumstances, but it also is very expensive. And Mr. Gentry can't just keep shelling out money because the order of the court isn't the one that Ms. Gentry or Ms. Tinsman would like. So we're asking that the motion be denied in its entirety.
Okay, thank you. Well, in this case, I do note that Ms. Thomas had stated that at the hearing that the referee had stated, and in fact had not fashioned any change in parenting time. And as she stated, apparently the referee had also queried, again, if the plaintiff was going to move. So there was apparently some uncertainty, and that it does sound now that she's moving, and obviously moving that amount of distance is a change pursuant to Shade v. Wright. And what the court does note is that the referee has the experience with this case, having gone through that. So the court is going to refer the issue of parenting time back to the referee for a hearing in which he can fashion a parenting time schedule, considering that the plaintiff is in fact moving to Virginia. So that will be the order, and court will do a referral order. Ms. McNiff, you don't have to do that.
The judge has had enough of the waiting. The house must go. Immediate sale, no mercy. Her Virginia move flips everything. Distance and custody explode into pure courtroom chaos. Holidays and summers spark a fierce fight. Every minute of parenting time becomes a battlefield. The case is sent back for redecision. Like the video, subscribe to the channel, and we'll see you in the next video.